Thank you for joining us. I am Liban Brummel. This is an NCN News extended interview. Attorney General AG Anil Nandlall had initiated legal proceedings against Brian Tiwari of BK Marine Incorporated on behalf of the state to reclaim the prime waterfront property, which he paid some $20 million for, though the property is worth $5 billion. Now, that has already happened. The case, however, has been dismissed, and it's raising some concerns among persons in society. I'm joined by the Attorney General and Minister of Legal Affairs, Senior Counsel Anil Nandlall. AG, thanks for coming. How are you today?
I'm fine, thank you, and thank you for inviting me to discuss this very important issue.
All right, AG. How about we start with a background to the entire case, and then we take it from there?
Well, Liron, you would recall you and I spoke on this matter, I believe, on two previous occasions, and I believe I was interviewed by a few other journalists in relation to this land transaction and many of its ilk. Now, the land in question is one of the most expensive riverfront properties owned by the state of Guyana. This land is located at the mouth of the Demerara River and is perhaps the first wharf facility at Port Georgetown. It is the most valuable of all the facilities in that line. I believe the valuation for the property is somewhere in the vicinity of about 8 billion Guyana dollars. Now, the property has a history, and for listeners and viewers to appreciate the recent decision of the High Court, it is imperative that I give some type of a background information regarding this property. This property was, and I believe still owned, by the people of Guyana. It's public property, it's the state property. You would recall some 30 years ago, a company by the name of NISIL, National Investment Company Limited, I believe is the full name of the company, was formed by the government of Guyana, owned fully by the government of Guyana, to which the government of Guyana would transfer state assets for this company to hold for the government of Guyana, and the government of Guyana will determine what it will do with these properties in due course, of course always acting in the best interest of the people of Guyana in relation to these properties, because that is the unreserved obligation that is owed at the fiduciary level to the people of Guyana regarding all public assets. Privatization is one of the methods that the government has used over the years in respect of properties transferred to NISIL by the government and held by NISIL for and on behalf of the government. The government, as I said, is the singular shareholder of the company. The directors of this company are all appointed by the government of Guyana. The chairman of the board is sometimes the Minister of Finance. Proceeds from sale and transactions in relation to these companies are periodically transferred to the consolidated funds. I say all of that to you so that you appreciate and your viewers appreciate the nature of this company and the type of assets with which it deals. The property in question was transferred to NISIL some decades ago, free of cost, for NISIL to hold until the government decides what it will do with the property, always being guided as a paramount principle by the best interest of the country. Sometime in about 2006, thereabouts, the government, NISIL decided that they will lease this property to BK Marine Inc. Now, it is what is called an investment lease. This lease has a number of clauses. Important among these clauses is a series of covenants which impose upon the tenant an obligation to invest and improve this property. In this case, there was an obligation to build hotels, to build restaurants, to build a facility where cruise ships can dock, to build a shopping plaza, to build stores where Guyanese, indigenous and other products can be marketed. It was supposed to be a tourist destination type of investment. There was a peppercorn rent charged, somewhere in the vicinity of about just over $800,000 per month. And another part of the facility was to be used to develop a modern wharf facilities where industrial goods could have been deposited, being imported into the country. So it was a massive undertaking between NISIL and the tenant. Provided that those investments were made in accordance with the lease, the tenant, after a satisfactory completion of the investments referred to in the lease, would have an option to purchase the property. The price fixed then was, I believe, 110 million Guyana dollars. That is, of course, contingent upon the millions and millions of investments
that would have been made,
that were to be made, in accordance with that lease. Anyone listening to this program can go and verify for themselves that none of those investments were made. In fact, the tenant did not even pay the peppercorn rent for a number of years, though he used, or the property was used, for the tenant's own private business.
Income generation.
In complete defiance and breach of the fundamental terms and conditions of that lease, which was the investment obligations and plan. Many notices were served upon this tenant to pay up the outstanding rents. These rents were not paid. Sometime in 2014, when I was Attorney General, NISIL instituted proceedings against this tenant for the outstanding rents. At that time, the outstanding rents ran into millions of dollars. While that case was pending, the government changed in 2015. A new government came into office, and the board of NISIL was changed, and a new board with a new CEO appointed. This new board, rather than continue to prosecute the claim already filed for rent outstanding, running into millions, and perhaps rather than explore the possibility of terminating the lease and retaking this valuable piece of real estate, whose value would have increased 100-fold, having regard to the fact that we became an we were becoming an oil-producing country at that point in time, in 2017.
And subsequent developments around the city.
And subsequent development around the city, the creation of shore-based facilities in very close proximity, where hundreds of millions of dollars are being expended. Rather than act in that direction, the then NISIL decided to settle the case, refused to pursue or even explore the possibility of terminating, and in contradistinction, gifted the property to the tenant by way of an agreement of sale. Now I want viewers to listen to me carefully. The purchase price that they decided to sell at was the same $110 million in the contract.
In the initial contract.
In the initial contract that was several decades by that time, or more than a decade and a half old. Knowing full well that not a single one of the investment obligations were satisfactorily discharged by this gentleman or this company, knowing full well, or they ought to have known full well, that the sale ought only to be activated upon the investments made, and that price of a meager 110 million was related to the completion of those investments, that you can't sever these two obligations, or else you will defeat the whole purpose and purport of the lease. In complete disregard of those fiduciary duties, NISIL sold this company for the $110 million. The purchase price, however, has a sum of $202 million. That differential between $110 million and the $202 million was the outstanding rents that were owed under the lease agreement. And they put a small sum of $10 million as interest, I believe,
annually for that period,
the rents owed. And that is what brought the property value, or the purchase price for the property, to $202 million Guyana dollars. So you understand what's happening there? Now, during the 5 months period after the elections, this transaction was entered into in 2017 by NISIL. The Minister of Finance, Winston Jordan, in July, I believe, of 2020, after they were defeated at the elections, and 2 years after a no confidence motion was passed against that government, in which the CCJ said that they were catapulted into a caretaker mode, in which it was clarified that a caretaker mode means that they are only to do the day-to-day running of government, that they are not to enter into new contracts, and certainly they are not to dispose of valuable state assets. This Minister of Finance issues an order, the effect of which was to pass the title of the property over to this company. That is after they have lost elections, you know. By that time, BK Marines, who would have entered into the agreement of sale, only paid 10% of the purchase price. So you have a minuscule purchase price of 202 million, of which only 20 million was paid as a deposit. But the Minister of Finance then proceeds to prepare a vesting order and vests that property over to that purchaser. And the vesting order itself says on its face that the property is being vested absolutely to the owner, to the purchaser.
Okay.
Free from all encumbrances and free from all liabilities. Meaning that BK Marines got absolute title without even paying the balance of the purchase price owed under the agreement. I am taking my time so that the level of vulgarity is seen by the members of the public, because it is their property and they must understand the horrendous state of affairs of what unfolded in relation to this transaction. And the saga doesn't end there. BK Marines now takes that, what you call the vesting order, takes it to the deeds registry, gets it converted into a transport, and get a value affixed to that transport to the tune of $400 million. So that he now can, or that company can hold that transport up and say that that property is valued $400 million.
There was a valuation done for that.
Now, the CEO, Mr.
Of Nissel at the time?
Nissel at the time.
Colvin Heath.
Colvin Heath, London. He was written to by the registrar, I believe, inviting him to object if he wishes. He wrote a letter to the registrar to say, proceed. And that property, valued 8 billion Guyana dollars, in those circumstances and in that factual matrix, was transferred to BK Marine after paying a mere 20 million Guyana dollars. One of the first actions that we filed when we got into government was that action. It was filed in the name of the Attorney General of Guyana. Now, why was it filed in the name of the Attorney General? The government of Guyana is the shareholder. The Attorney General, under the State Liabilities and Proceedings Act, is authorized, and under the Constitution as well, as the legal advisor to the government of Guyana, is authorized to file any proceedings for and on behalf of the government of Guyana. The government of Guyana, as I said, is the shareholder. It is the shareholder that lost the property. The Attorney General sued NISIL because NISIL acted in complicity with and in conspiracy with this company, violating all fiduciary obligations to its shareholders and to its owners. Hence the Attorney General filing the action. Our law is very clear. Minority shareholders can sue. The government here is not a minority shareholder. It is the only shareholder. Are you telling me that the laws of Guyana prohibits a shareholder who is robbed his property by his board of directors? That shareholder is prohibited from filing proceedings for negligence, for breach of fiduciary duties, for fraud if my property is sold for less than the market value and even that is not recovered. Just transpose that to a private company. Imagine one of the leading private corporations in this country that has many shareholders, that their most valuable property, their headquarters, is sold by the board of directors. That headquarters is valued 40 million US, but it is sold for $4 Guyana. That is what the shareholders own. Are you telling me that the shareholders have no right to do anything because of corporate veil? That is not the law of no country on planet Earth. And there are authorities across the Caribbean and elsewhere that would justify the Attorney General suing. The learned judge, the case did not go to trial, you know. An application was made to strike the case out on two grounds. One, the Attorney General is not authorized to bring the case. And two, that is, the case is frivolous and vexatious. I have just outlined to you there the facts. The causes of actions that the Attorney General sued for were negligence, breach of fiduciary duty, the tort of conspiracy, misfeasance in public office, misconduct of a public officer, fraud. These are serious causes of actions. This judge found, without hearing a shred of evidence, that the causes of actions are not made out. They are frivolous and vexatious. And he struck all out. And the Attorney General is not a proper party. That NISIL is a proper party. This decision is one of the most shocking decisions I have ever witnessed in my brief career at the bar. These facts that I have narrated are some of the most contumacious set of facts and circumstances ever unfolded before a court of law. Then there are technical rules which I can explain if you wish. Any lawyer worth his salt will tell you a couple of things. One, the new civil procedure rules that we have mandate courts to hear cases on their merits and don't dispose of cases that will necessarily be appealed and then they will have to come back to be started over. That each case must, as far as possible, be determined on their merits, save and except in the most exceptional of cases. There's another body of rules and jurisprudence that say that the striking out of a litigant case without allowing that litigant case to go to trial is the most draconian of measures. It is denying a man or a woman or a party a fair hearing. And if you're going to do that, you must do it in the most exceptional and in the rarest of circumstances. And those are principles that are 100 years old. They say you never drive the plaintiff from the judgment seat unless you have a most exceptional and the clearest of cases, having regard to the facts that I have just recited. At what level you have to be? What must be motivating you as a tribunal to find that those facts narrated, and I can make the statements of claim public, well, they are public, that those do not constitute, or those constitute frivolous set of facts that shouldn't go to a trial. Another point that I want to make before you come in. There is also another body of rules which say that if you're going to take this draconian type of action, you must do it at the earliest stage. That if a party files a defense, he's taken to acquiesce to whatever technical difficulties and flaws the claim is afflicted with. Once you take a step by filing a defense, you are taken to have waived and acquiesce, and you no longer can take a preliminary strike. In this case, a defense was filed by BK Marine and the other defendants, as well as a reply was filed by the claimant Attorney General. So in other words, this case was supposed to go to trial, and then a sudden change of heart. The case suddenly became vexatious and frivolous and not worth going to trial with. And the Attorney General suddenly became an improper party. Those were matters that supposed to have been dealt with at the very preliminary filing of the case.
You've outlined what actions were taken. You've outlined what has happened. The next step from here in government is going to be an appeal, I assume. Has that already been filed on the books?
This ruling came from the judge yesterday. And it has shocked me, and perhaps it should not, when I reflected on certain matters which I am not permitted to say. But I have decided to come here and to speak to the people of Guyana because it is their property and they must form an opinion on what transpired. What I'm doing here is not a usual thing. I don't normally do it. Errors can be made. I know. It's not yesterday I'm a lawyer. Errors are human. An appeal, and when errors are made, I don't complain. I go through the process. An appeal will be filed. And this case will go all the way. This is a travesty of justice that must be corrected. I am not going to attribute any motive to any judge or to the judiciary, and I have not done so. I have exercised great restraint. I know what my duties are as an attorney at law, and certainly as Attorney General of this country. I also know what my public duties are to the people of this country. I am representing their interest. And in this matter, their interest has been trampled upon. And it is my duty to tell them. And to explain the facts as I understand them. And that is what I'm doing here.
When can we expect an appeal to come in for this? Tuesday.
The claimant has 6 weeks
In
to
which?
appeal. The learned judge has not yet given his written ruling.
Okay.
Prudence would dictate that that written ruling be awaited, studiously examined, and grounds of appeal prepared after that examination.
Yes, sir.
Hopefully I get that within the time frame permitted for the filing of this appeal, and we'll take it from there.
We'll take it from. So at this stage, the summation of it is legal action was taken. The case was thrown out because it was determined to be vexatious. And as you explained, the process and only when that is supposed to be applied. And an appeal is to come within the next 6 weeks from government.
Compare this, for example. Oh, there's one omission I made. It is this. The court proceeded to award $2 million in costs against the state for each of the persons sued. Jordan was sued, Nissil was sued, BK Marine was sued, and I believe Keith London was sued. Those were the persons who were sued. The state got to pay over $4 million in costs. After what the state suffered at the hands of these respondents, the state now has been ordered to pay them back their costs. How can I not come on this television and explain to the people of this country what has transpired in this matter? You tell me how. You've been listening to me attentively. Compare that with the case where an action was filed against the Attorney General because the President did not consult with the leader of the opposition for the appointment of a Commissioner of Police, when at the time there was no leader of the opposition with whom the President could have consulted. In that case, the judge said that the case is frivolous and vexatious. You compare those facts where there is nobody to consult and the President has an obligation to act. What does the President do?
He acted.
Sit idly by while Rome burn, or discharge his duty when he is not responsible for a leader of the opposition to be in place? And when he discharges his constitutional duty, he is sued. Now a judge has declared that as frivolous and vexatious. Compare that to what I just recited, and you will see. And that matter, that judge heard it on its merits before making that determination. That learned judge heard that matter on its merits. This one, with these facts that are strikingly different, were dismissed summarily without a shred of evidence. Any lawyer will tell you that once fraud is alleged in relation to a transport, a trial ought to be held. Once fraud is alleged, A trial ought to be held. Fraud cannot be determined by any other way other than by a trial. An allegation of fraud. Here we had about 3 pages of elements of the fraud pleaded. And this court found, summarily, there is no fraud.
AG, I thank you for explaining and bringing to us the facts of what was put out there. I know in legal terms and in it you can't express too much of what has happened since the appeal is yet to come. It's not the finality at this stage. I wish you and the state the best in the appeal going forward, and we look forward to hear more coming out from this decision that was given.
Thank you very much, sir. And thank you for inviting me. And I think that I have done my duty to the people of Guyana.
Thank you.